All right, guys, here we go. Everybody ready? We're going to start off by talking about two cases that were decided uh, dealing with issues related to 39-6A 4.5, which is the statute which bars causes of action in instances where individuals are convicted of either drunk driving or refusing to submit to a breath test, or in those situations where an individual operated a motor vehicle that he owned that had no liability insurance. Both of the cases we're going to be talking about are on their way to the Supreme Court. The Supreme Court has granted cert in both of them, although I think in one of them there was a dissent, so they had to. But in either event, both of the cases we're going to talk about implicate very broad public policy issues, so the final word will come from the Supreme Court. A year from now, we'll probably be reviewing these cases again in terms of what the court had to say about them. A little bit of background about the statute first, and I want you to just kind of take a look at it. I have it up here on the board. One of the reasons I put it on the board, not only to kind of just talk about its elements, but also to stress to everybody in here, if you do any type of work in the municipal court context where you're representing people who have been charged with drunk driving and refusal or charged with operating without liability insurance, you've really got to be super aware of this statute. And if you anticipate that there could be a cause of action anytime during the statutory period, you've really got to do what you can in order to defeat the underlying charge so as to not deprive your client of his cause of action, all right? It can have catastrophic consequences. I had a case of my own where this was actually referred to me by a big personal injury firm, where my client was stopped at a traffic light and just waiting for the light to change. A vehicle came over from the other lane and hit him head on and just clobbered him. He was in a situation where he's going to need a respirator and be in a wheelchair for the rest of his life, and just had unbelievably horrible injuries. The blood alcohol level taken from him at the hospital was a .09, and the police wrote him a ticket for drunk driving based solely upon the fact that he had a per se violation. There was no driving conduct from which they could prosecute him, but he did have the prohibited level of alcohol in his system. So a plea of guilty under those circumstances, or a finding of guilt after trial, would have been devastating to him because he would have lost any cause of action that he had. They hired me to represent him on this, and just my mission basically was to do whatever I could, have him plead guilty to anything, including murder, just to avoid the consequence of the 39-6A 4.5 statute. So let's take a look at it. Any person who at the time of the automobile accident resulting in injuries to that person is required but fails to maintain medical expense benefit coverage mandated by 6A-4 shall have no cause of action for recovery of economic or non-economic loss sustained as a result of an accident while operating an uninsured vehicle. Now notice it's really weird how they have it set up here. It doesn't necessarily have to be the defendant's own vehicle. I guess you could have a vehicle that you didn't insure and be operating somebody else's uninsured vehicle. But clearly, if you're operating your own uninsured vehicle, which is what's going to happen in most circumstances, you're going to fall within the mandate of the statute. Notice the prohibition on economic and non-economic loss, so pain and suffering is going to be thrown into the mix. The case law has also interpreted this to mean property damage as well. So we're talking about your medicals, pain and suffering, property damage, and things of that nature. The only thing you're really going to be able to get out of this, it's not statutorily barred, is PIP coverage. PIP is excluded from these definitions. But other than that, your cause of action is gone as a result of the operating a motor vehicle that you own that has no liability insurance. Under B, there's a little bit of a trick to B. A person who's convicted or pleads guilty to operating a motor vehicle in violation of the 450 statute, and take a look here at 39-450.4A, which is the refusal statute, also constitutes the bar. Or a similar statute from another jurisdiction, so it could happen someplace else. In connection with an accident shall have no cause of action for recovery of economic or non-economic loss sustained as a result of the accident. It's interesting to me that when the police go through and they read you the requirements that you submit to breath testing when you're arrested for drunk driving, this is commonly referred, the standard statement is commonly referred to as paragraph 36. They list all the bad things that could happen to you. One of the things that's not in the warning is this, which is probably the most important thing that you should know about when you're making your mind up as to whether or not you want to submit to a breath test, something I think the Attorney General should really take into consideration, but that's for another course in another day. Now, the statute has been subject to a fairly significant amount of litigation challenging its constitutionality. It was ruled to be unconstitutional in a decision by the late Judge Pressler in Yeah, Caviglio versus Royal Tours. I don't know, just had a brain meltdown for a second. Caviglio versus Royal Tours, and I remember the example that she gave in her opinion. She talked about how nonsensical the statute is, in the sense that you could have a situation where you have one drunk driver hit by another another drunk driver, and the drunk driver, who's completely innocent in this case, by virtue of the fact that he's intoxicated, would lose his cause of action under this. In any event, very, very, very unusual for Judge Pressler to be reversed by the Supreme Court, but that's exactly what happened in this case when the Caviglio versus Royal Tours matter went to the Supreme Court. They reversed the holding of the appellate division in Judge Pressler's decision and found the statute to be constitutional. By the way, Bob, I want to come over here. Let me introduce you to everybody. Then I want to ask you a question. We'll put you on the spot here. Come on over here. We got to be on mic. Everybody, this is Bob Rubinstein, as I mentioned a moment ago, who is a certified certified civil trial attorney. Criminal, that'll be some other day, right? Quick question. Let's take a situation where the defendant's highly, highly intoxicated and drives his vehicle and gets killed. All right? He's drunk, no doubt about it. Do you think the statute is in play?
Absolutely not, because in that scenario, he's never been found guilty of a drunk driving offense.
So just if he has the insurance, then he's going to be in good shape?
Correct.
And you're not going to have a bar for survivor action or for wrongful death?
Correct, because there has to be a finding of guilt.
Okay. Thank you. Is there any charge for that legal advice?
No,
All right. So we know the statute is constitutional. We know it has a particularly harsh result. And that's really kind of well established in the law now. What has been going on, the pattern we've seen now over the years since the Caviglio case has been decided, has been a series of challenges on other types of causes of action which are not necessarily set forth in the statute. And we're going to be dealing with two of them today. I just want to point out to you that the first challenge that was successful came about in Kemp versus Lamino, dealing with a social host liability suit where alcohol beverages were served to an underaged individual who was involved in a motor vehicle accident, and then brought a suit against the social host who provided her with the alcohol beverages. Now remember, this type of cause of action is not statutory in nature. This is a common law cause of action, and the defense was raised because there had been a guilty finding to drunk driving in that case, as to whether or not the statute barred this type of cause of action. The appellate division in Kemp versus Lamino said it does not. The public policy reasons supporting this type of cause of action against social hosts has nothing whatsoever to do with the purpose behind this statute, which is essentially to decrease the premiums for liability insurance. The two cases we're going to talk about this morning deal with additional issues, the first one being Voss versus Trek Aleta. This is a case that comes out of a dram shop action. Now remember that the dram shop is statutorily enacted in order to basically provide a mechanism for the bar industry, so to speak, restaurants and taverns, to be able to get liability insurance. I mean, unless there was some certainty in the law and the elements of the offense were kind of set out, no one would ever insure these individuals.